I declared my asset on assumption of office in 2017. I declared my asset right after my term of office lapsed. I have a copy here I can give to the committee. So I've always been in compliance with the law. That is why I say that I'm not in any fear at all, even though the Ghana Integrity Initiative report has not come out. Secondly, yes, I said 100 applications a week, not 100 applications per day. And the applications are not tender processes. Thank you. They are applications to engage in a procurement method. So the application for procurement method, no application for a tender, not at all. Now, Article 78(3), yes, anticipates that public officers shall not hold any other office of profit. And indeed, that chairman, I have not held any other office for profit all my life. I mean, as a public, when I've been a public officer, I've never held any other office for profit. And that's why I indicated that even though I formed a law firm, I think in January, February 2017, once I got to know that I incorporated a law firm. Once I got to know that I was going to be Deputy Attorney General, I never registered a chamber. The chamber is there. Most Attorney General, Deputy Attorney General have always had chambers. I have not had any chamber, just because of possible conflict of interest. Now, secondly, I think that it is of utmost necessity that the Public Procurement Authority Board will have a representation of the Attorney General. The representation of the Attorney General on boards, or public boards, if I may say, is not only in relation to the PPA. The Attorney General has representation on many boards, from NHIS to the PPA. I mean, all manner, whether defense, health, finance, security, the Attorney General is represented there. Because that is to guide, it is actually a way of guiding. And the PPA board, in fact, even my record, it actually ascertained on the PPA. They will indicate to you how I've, on crucial occasions, guided the board legally. And that is why, apart from the conduct in question, no member perhaps has found himself in any conflict of interest. So, Mr. Chairman, I will say that contrary to the view of the honourable member, the Attorney General ought to have a representation on the board.
Well, thank you. Maybe you have to look at 78(3) again. It talks about private or public, not only private. You responded to the private, but that's fine. We can move on. It's also instructive that a while ago, in answering the question, you made reference to a letter that quoted the wrong portions of the Act. When I think the leader on our side engaged you, and it's instructive that you were guiding them as you suggested. But to my next question. As Deputy Attorney General, you supported and led government's revocation of the mining leases of Exton Quebec Group Limited. Now, the central plank of government's case, which you led, was that Exton Quebec Group Limited leases had not been ratified by Parliament, and they had no right. My colleague and I, Honourable Member for Ashama, identified and filed against 35 mining companies that were carrying out mining in Ghana with leases that were not ratified through our lawyers. We filed this. 2 years on, the case hasn't been called. Now, Honourable Nominee, given these facts known to you and government apparent disinterest on the operations of these other companies and our suit against these companies, how do you convince this committee and the people of Ghana that you were not being vexatious, impartial, and capricious in your strict application of the law on Exton Quebec Group Limited, and whether on that basis you can be trusted to be a fair Attorney General for Ghana, given the provision of Article 296 of the 1992 Constitution.
Right. Mr. Chairman, I defended the Esteem Cubic matter. Gentlemen, sorry. Gentlemen, so the Attorney General is supposed to be a defendant in all civil cases involving the government under Article 88(3). The Chairman, consistent with this duty, I defended the application filed by Esteem Cubic. And I say I defend, I mean, as a defendant, I pursued it vigorously. In the same way, I defended the suit that my good friend, the honorable member, also filed. And I do not know why I filed a single case. I'm sure my good friend has received it. I filed a defense, formal defense, your action. I cannot explain why the Supreme Court has not listed it for hearing. The only point I can make is that the point that my good friend sought to make in that case has already been determined by the Supreme Court in the Ndebugui matter. The Ndebugui matter, even before I assumed office as Attorney General, had held that Article 268 enjoined every mining lease to receive parliamentary ratification. And the absence of parliamentary ratification, a mining lease is invalid. That is clearly the import of Article 268 when it says that every mining lease shall be subject to parliamentary ratification. Subject to is indicating or is indicative of the fact that until the happening of that event, it has not become valid. So that's the position I took also in the Esteem Cubic matter. But beyond that, I also recognize various statutory infractions engaged in the processes leading up to the grant of the mining leases. So it was not a simple case of the absence of parliamentary ratification, which led to the filing of my opposition to the application that had been filed by Esteem Cubic at the High Court first. I raised various statutory infractions and violations engaged in the processes, that there was the failure to gazette the mining lease in accordance with laws, the failure to give the relevant notices to all the traditional authorities and what have you. And of course, the Supreme Court in its judgment noted the statutory infractions in addition to the constitutional violations that characterize the grant of the mining leases. And I think that that's the most faithful way an Attorney General ought to discharge his or her functions, that when assets of the nation had been, with all respect, appropriated or allocated to a company in violation of the statutes of Ghana, in violation of the Constitution, the Attorney General should be the first person to take action. And I was not even the first person. The company sued and I defended. And when the ruling, I did not appreciate the ruling, I went to the Supreme Court and the High Court quashed the High Court's judgment.
Well, Mr. Chairman, I think the nominee didn't address my question of vexatious and capricious use under Article 296. It is not about whether Esteem Cubic was right or wrong. It's about the fact that there were other 35 mining companies operating at the time with, if you would like to call them defects, similar defects, which was overlooked. That is the point that I sought to make with my question, which hasn't been addressed. And whether that does not qualify for one to wonder if we will have a fair Attorney General. But I'll move on, Mr. Chairman, to my next question.
If you permit me to clarify.
Okay. I mean,
the chairman, yes, the 35 mining leases now he's bringing in as an element in his question. Chairman, the point I'm making is that, yes, just like Esteem Cubic, I again exercise my duties fairly by filing a defense to your suit. The suit is still pending in the Supreme Court. The Supreme Court is yet to make a determination of it. I do not think that we can, in all fairness, make suggestions that the mining leases in question had labs and that the government of Ghana is condoning them at all. I will not even do that at all.
Follow up to the answer. You follow up on the answer, not his question.
Thank you. So, Honorable Attorney General designate, if I got my colleague's question correctly, his suggestion was that you had been vexatious. That is to mean that in initiating an action, your response was not clear. Is it the case that in the Exton Cubic, you initiated the action? Because I think the basis of his question was that there are others who violated the law, but they were in operation and you didn't initiate an action in court against them. So he's suggesting that you were vexatious in that sense by sending them out. Is it the case that you were the one who initiated the action in court?
No, Mr. Chairman, definitely not. I was not the one who initiated the action in court. The action was initiated originally by Exton Cubic in protest against the determination by the then Minister for Energy that 8 leases were of no effect. Then I defended the action, and the ruling the High Court judge initially held recognized the statutory violations and infractions that I had alleged. The High Court judge upheld those violations, that upheld the claim of those violations. But then in its conclusion, the judgment quashed the letter written by the Minister for Energy. In the face of this, I proceeded to the Supreme Court that the judgment given by the High Court was actually in excess of its jurisdiction. The Supreme Court upheld my contention and further affirmed the statutory violations and breaches engaged in the processes leading to the grant of the leases. And I'm saying that in respect of the 35 million leases, the same situation applied. We defended the action that had been filed by Honorable Sumini together with other people. The action is still pending in the Supreme Court. The Supreme Court is there to make a determination on the matter.
Chairman, just one other follow-up. In your answer to the Honorable Suhini, you sought to rely on the Supreme Court ruling on Indebugri, as you referred to it in Article 268, which deals with ratification of mineral rights and contracts. Are you suggesting by inference that those 35 other mining companies are operating in violation of the Constitution per the ruling of the Indebugri case?
Mr. Chairman, indeed, if the honourable member will recollect, our defence in the matter that he filed raised constitutional issues about the propriety of his action. Mr. Chairman, I have not examined the specific facts and circumstances of each of the mining leases that were alleged to be non-compliant with Article 268. The action itself did not raise sufficient constitutional issues warranted the invocation of the Supreme Court's jurisdiction. And that constitutes a defense that the Attorney General can mount. Indeed, the Attorney General raised that as a preliminary point. And that preliminary point is there to be determined.
Yes, please continue.
All right, to my third question now. Honorable nominee, I came across a very interesting article entitled Dying for Justice, edited by Hamid Akwal and Jenny Bond, and a foreword written by Colin Prescott, who is chair of the Institute of Race Relations, caught my attention. The first sentence: first, you are wrong, and then you are wrong-footed. The process and procedures for getting justice are all smoke and mirrors, quote and unquote. First, you are wrong, and then you are wrong-footed. The process and procedures for getting justice are all smoke and mirrors. When I saw this, Gregory Afoko came to mind, and then recent developments came to mind. In the context of our justice system, which has been variously, through research, described as slow, corrupt, and sometimes biased, what will you say about this quote as it relates to justice delivery in Ghana, and how you will contribute to perhaps improve what the case is?
The case of Gege Afuku must be looked at within the peculiar facts of the matter. Now, the gentleman was arrested and tried for murder. The police docket indicated that there were two persons who should have stood trial for the charge of murder. The other gentleman had absconded from the jurisdiction, so the trial proceeded against Gregory Afoko alone. Mr. Chairman, the trial proceeded, and then about 2 or 3 years down the line, it was found, the gentleman was arrested in Cote d'Ivoire and brought into the country. Mr. Chairman, in order to prevent a compromise of the evidence, a dispersion of the evidence, and thereby a failure of justice, the Attorney General, in exercise of her right to enter a nolle prosequi and to control criminal proceedings, proceeded to enter nolle prosequi in the first trial of Gregory Afoko. It was that decision which led to Gregory Afoko actually proceeding to the Supreme Court, and which resulted in the judgment that I earlier on referred to, that the Attorney General's power to enter nolle prosequi has been upheld by the Supreme Court and has been held to be unquestionable. When the nolle prosequi was entered, necessarily, yes, a fresh proceedings for a retrial of both Gregory Afoko and the gentleman who had been arrested in Cote d'Ivoire commenced. The chairman, Mr. Afoko, then filed applications for bail in between the period that the nolle prosequi was entered and the period that the new trial began. He filed applications for bail. The High Court indeed granted one of the applications for bail. But then after bail is granted, there is a statutory process for a satisfaction of the conditions regarding the grant of bail. So it is not just a simple case of a person having been granted bail, which will entitle that person to just walk free from the cells of prison. Mr. Afoko, unfortunately, struggled to meet the terms of the bill. Indeed, the record will show that the High Court, he was brought to registry numerous times and the bill was not satisfied. The chairman, subsequently, as I indicated, the fresh prosecution began. And then he was arraigned before the court. Having been arraigned before the court, the new judge exercised a discretion to keep Mr. Afoko together with the new gentleman who had been arrested in custody. And that is what happened. And the trial is going on. It's a jury trial. I believe that will be sufficient for the committee. And then also, regarding the quotation you quoted, yes, I also counter it with the fact that the right to swing your arm ends where my nose begins. And I think that in the recognition and enforcement of human rights, it's important to have this mind. That is why the people of South, with all respect, find their case a little unfortunate. Yes, they have the right to vote, but the right to vote must be exercised within the confines of the law, and that is, as I said, in Boehm, termed by law. Therefore, even though they have the right to vote, they didn't have the right to stop the people of Ohoi from enjoying the exercise of their franchise and by having their member of parliament sworn in. So the right to swing your arm or to swing your fist also ends where my nose begins. That's it, man.
All right. It's interesting you have introduced South. My last question, Mr.
Samuel, no.
My last follow-up, please.
You have had so many lads already.
Oh, just a follow-up, Mr. Chairman. In fact, this is even my comment.
Okay.
Thank you. You introduced Sal. I wish I had more time, I had another opportunity to discuss that with you. But I will end with a follow-up to some answers that you gave earlier. I have in my hand a letter dated 25th January 2019 addressed to the Honorable Minister of Finance, Mr. Ken Oforiatta, titled RE Suit Number CMRPC/0624/2018, Niamanu Dodo versus Dr. Kobna Dufour and 16 others. Notice of intention to join the Attorney General. Preliminary observations and request for comment. Now, I'll just go through some few portions of it with the permission of the Chairman. We have examined all the processes and documents so far filed by the various parties in the matter, as well as the documents received from Bank of Ghana, and find the following facts as irrefutable and fundamental to an opinion on the legal issues arising in the suit. Then the facts that you consider irrefutable are listed. I will not want to go through all of those facts for purpose of time. But here it says, from the decisions taken by the Bank of Ghana on 1st August 2018, it is apparent that the mandatory duties of a receiver, such as publication and registration of notice of receivership, and taking of an inventory of the assets and property of Unibank, and publication of sale in 2 daily newspapers of national circulation were not done before the receiver entered into the purchase and assumption transaction with CBG. And then finally, we note that CBG was incorporated on 1st August 2018, and a certificate to commence business was issued to that bank on 2nd August 2018. We also observe that selected assets and liabilities of the 5 banks were transferred to CBG on 1st August 2018 via purchase and assumption transaction before the grant of a certificate to commence business. Section 27 of the Companies Act 1963, Act 179, prohibits a company incorporated in Ghana from transacting a business until it has satisfied the provisions therein and has been issued with a certificate to commence business. A violation of this provision constitutes a criminal offense for which the company and every officer of the company shall suffer a penalty prescribed by Section 29 of Act 179. The transfer of selected assets and liabilities of Unibank on 1st August 2018 is business which CBG was not authored by law to engage in as of 1st August 2018. Is this authentic, Honorable Nominee? Is this authentic?
Yes, it is, but just like the earlier opinions of the Attorney General that I alluded to. And indeed, as is apparent on the face of the letter considered preliminary observations and comments. I believe that was the title, preliminary observations and comments. Yes, and that was replied to by the Bank of Ghana later on, because the Minister for Finance drew the attention of Bank of Ghana to this, and they provided explanations. And subsequent to that, the position of the Attorney General is contained in a defense reaction that we filed in court. And it will interest you to know that after the defense was filed, the Attorney General initially emerged victorious because the matter, after being referred to arbitration, our defense at the arbitration hearing was appealed. Bank of Ghana did not file a defense, but we filed a defense. The defense was appealed by the arbitrator, and the matter was struck out by the arbitrator. Subsequently, the defendants in the matter, Dr. Dufour and Co., instituted a fresh action, and that action is both the subject matter of arbitration and the subject matter of a court of appeal matter. So I think that I will reserve a comment on the matter.
On that note, first you are wronged, and then you are wrong-footed. The process and procedures for getting justice are also chaos. I thank you, Mr. Chairman.
Okay.
I thank you, Mr. Chairman.
Can you put yours off as well? All right. Is Gisela, because she hasn't spoken today, I'll give Gisela before I come to you here.
Thank you very much, Mr. Chair. Honorable nominee, what would you advise the President to be the limits of judges for the Supreme Court, assuming you were to be confirmed as Attorney General? Because, or what are the indices, if I may ask? Nigeria has a population of 206 million.
If you wish to stretch a little, I'll permit you to stretch for 5 minutes. I also want to use the washroom anyway, so.
Mr. Chair, do I suspend my question?
So when we come back, we'll resume.
Thank you, Mr. Chair.